Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
The Court of Federal Claims agreed that the Navy mishandled affiliate past performance in a major procurement, then rejected the protest on procedural grounds. The Noblest decision is a cautionary tale about record discipline, expert evidence, and the limits of post hoc fixes. Here to walk us through the case is Zach Prince, partner at Haynes Boone. Zach, thanks so much for joining me today.
Thanks for having me, Terry.
Tell us about this Noblest protest case and why it landed at the Court of Federal Claims.
Sure. So this decision was about an approximately $100 million procurement by the Navy for engineering, technical, and programmatic services to support computer systems and networking for Program Management Warfare 160, PMW 160, tactical networks, part of the CANES command and control program. This was a best value procurement. The Navy essentially evaluated both the awardee, Salute, and Noblest, the protester, as equivalent in all factors except cost, where Salute just barely edged Noblest out by about $7 million out of $107 million, $109 million, rather. So the Navy awarded to Salute. Noblest protested first to GAO, lost, and then brought this case to the court.
The core issue in this case seemed to circle around past performance. So walk us through what the behaviors were that led to the protest.
Sure. So past performance is somewhat of a vexing issue in many procurements, and it's never been entirely clear to me when your corporate affiliate, parent, subcontractor past performance will be considered or won't when the rules are otherwise silent in the solicitation. And some of the solicitation is very clear when it will and when it won't. The FAR is a bit ambiguous. The case law has been a bit scattered, and that was a helpful hook for Noblest here.
Tell me more about why they went that angle.
So Judge Solemson here goes through a lengthy explanation of the different categories for consideration of related parties and subcontractor past performance. And it's very helpful to have this laid out as a framework. So he explains that there are four different possibilities. There is a total exclusion, where the solicitation just says expressly, no, you can't use subcontractor or affiliate past performance. It's only the contractor's past performance. That's clear. It doesn't, to me, make very much sense when you've got teammates that you are, in fact, expressly relying on for their technical expertise, and you call it out in the in your proposal. But it's a possibility. Sometimes the agencies select it. You have to live with it or challenge it in advance, or risk waiving that challenge. Permutation 2 is limited credit. The solicitation might say, yes, you can use subcontractor and affiliate past performance, but it might restrict reliance on that past performance or corporate experience for evaluation credit to some extent. It might say that you only get a certain amount of credit, or define in some way what that credit looks like. And we've seen that show up in a number of protests, and this decision helpfully goes through some of those decisions. Number 3 would be a committed teaming arrangement. The solicitation might permit use of subcontractor affiliate past performance, allow consideration by the agency, but require proof that the offeror has actually entered into some sort of agreement that demonstrates how the affiliate will be used. A teaming arrangement would be one type of scenario, or a subcontract, clear subcontract with terms, is something to that extent where you clearly are explaining what you're doing with the subcontractor or teammate. And the fourth category, which is where we are here, is the default. As the solicitation is silent about affiliate and subcontractor past performance, either how the agency will consider it or what an offer has to demonstrate to obtain credit for it. And then the default rule, as Judge Solemson explains, is that the agency can consider the experience so long as there's an explanation of how they're going to be used. That is, you can't just say, we get credit because they are affiliates or because they're subcontractors. You explain, this is how we'll use our subcontractors, this is how we'll use our affiliates, and why it's reasonable to rely on it. Here, the issue was it was a silent solicitation about this issue. The agency relied on Salute's affiliate past performance but there was no explanation of how Salute, the actual contractor entity here, would be able to draw on the parent entity's personnel. And that was fatal for the analysis from the Navy.
So Noblesse actually succeeded in their argument about the past performance consideration, correct?
They did, and they lost in a couple other points, and they had lost on this point before GAO, but they did convince Judge Solemson with a fairly complicated but ultimately successful argument. But there's a big but. It was a Pyrrhic victory.
So tell me more about how, if they were right, they still lost.
Yeah, this is so galling, and I don't know how this happened. But one of the big issues in a federal procurement dispute is that even if you are successful, you have to explain why, and there's a 4-factor test, the court should issue a permanent injunction against the actions of the government. That is, why is it in the public interest that in this case, the court has to tell the government how it must act in a procurement? And they just didn't do that here. Noblesse completely failed. I don't know what happened. I haven't studied the briefing, but I do know Judge Solemson, and he certainly wouldn't make this up. They did not do an adequate job, or seemingly any real job, of explaining why the balance of equities or any of the other factors of that test fall in their favor.
Would those sorts of arguments be presented simultaneous with the argument for injunctive relief? I mean, are they two parts of the same case, or are they sequential?
It's part of the same argument. So what you would do, you put it into your complaint, right, which initiates the pleadings at the court. You might amend that complaint later. Parties are not always great at doing that in bid protests because things move so quickly, but ideally that's what you would do. And then you put it in your briefing, your motion for judgment on the administrative record, your MJAR. And you would explain first in detail why you win, and then you would explain in detail why, because of these errors in the procurement, the court, based on the 4 factors for permanent injunctive relief, ought to grant that relief. I've seen cases that lose on the injunctive relief point, even when they win on the merits. It's rare, but the government will successfully argue that for national security interests or some other reason, the public interest is in favor of letting this thing ride, even though there is an error.
It seems then that there might be 2 sets of lessons that we draw from this case. One is about the reliance on affiliate or subsidiary past performance in their proposals. How should contractors think about the lesson out of this case for that consideration?
Yeah, this is an important point because I see this a lot, especially with platforms of companies where they're all related, they're all under common ownership. They think of themselves as one entity. They're not one entity. The contractor's identity matters. And Judge Solemson here talks about this notion of privity of contract. That is, there is a contract between the government, or will be, the government and a single legal entity, right? That legal entity is the one who's on the hook if there's an issue. It's the one that gets paid by the government. And that entity is not indistinguishable from its various corporate affiliates. And there are meaningful legal distinctions there. So if you're proposing and assuming that you can rely on all the capabilities and past performance of other legal entities, even if you absolutely can, you have to make sure you're showing the agency why that's the case. And corporate form matters. I've seen some really sticky legal issues arise because of this issue. Companies just treat entities as indistinguishable when they legally are, in fact, separate. You can't do that. And of course, the same is true for subcontractors, right, which are not affiliates.
The second lesson set seems to me to be for the lawyers and how they prepare the case.
Yeah, it is. And it's a painful case to talk about because Noblesse had good legal counsel, folks who are well known and respected in the industry, which I think just emphasizes that this can happen to anybody. Don't get lazy. Briefing deadlines are real life intrudes, but if you miss something central like this, you will lose a whole case for your client. And I can't imagine how that call went with Noblesse. You win, but sorry, you lose because of this prejudicial error that we made.
What about the lesson for agency contracting shops? How should they think about this and the clarity that best suits a solicitation?
Yeah, they just need to draft coherent solicitation terms. And past performance becomes an issue that is disputed almost every time in a protest. And sometimes it is a matter of discretion and you're challenging an agency's reasoned determination. But sometimes it's the case that the solicitation just should have been clear. And either the agency needs to say, yes, we do want to think about your affiliate or your subcontractor past performance, and this is how you go ahead and submit it, or not. But they can't just say past performance is an evaluation factor and then just throw up their hands and let things play out.
Zach Prince is partner with Haynes Boone. Zach, thanks so much for joining me and walking us through this case. Important lessons here.
Thanks for having me, Terry.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.